So good morning, everyone. I hope you've had a nice break since our first session. I hope everyone can hear me. Can you hear me? Can you?
Yes, we can.
Okay.
I can hear you.
I'd like to begin by welcoming everyone to this session. And we will start with the national anthem. Bless this our land and nation. Justice be our shield and defender. May we dwell in unity, peace and liberty. Plenty be found within our borders. Okay, so thank you for coming to this session. Just before we begin and I introduce the speakers, we'll go through a little bit of the housekeeping. If you have a question or you'd like to comment, share your experience in a particular topic or in the sector, feel free to use the chat tools. Indicate all your questions there and we can be able to adjust them at the end of the session. Secondly, please keep your devices muted so that we can be able to record well and we can also be able to hear our speakers clearly. Yes, so our session for today will be talking about rebooting the employer-employee relations in Kenya, and we'll be having a masterclass on that. And we'll be talking about labor relations and the Kenyan Employment Act. So our session, I'll give an overview of the session and how exactly it will run. We will start with a commentary by Ms. Susan Wendot, who is a HR practitioner. So she'll basically be giving us her insights in the employment sector and as well as relating it to human resource. Secondly, we will have our main speaker for the day, who is Ms. Gladys Wamaitha, who has been an advocate in the High Court, and she will be talking about the Employment Act and just giving us an in-depth analysis of the Act and sharing her knowledge with us and her experience in the sector. She's been an advocate for the last 20 years. Thereafter, we will have a short commentary by Mr. Rashid. Hopefully, he'll be able to join us in time to give us, Mr. Rashid was there, and he'll be able to share with us a couple of insights on what his views are. And then we'll open the discussion to everyone else and we'll be able to engage and share what we think. So I'd like to invite Ms. Susan Wendot to just come in and give us her commentary on the design of human resource and practice ecosystems in Kenya. Thank you so much. Susan, kindly unmute.
It's refusing. Hello, everyone. Thank you, Amanda.
Thank you.
I'll start by just mentioning what human resource management is. That human resource management is a subset of management where it has goals in the organization to attract employees, to hire employees, train employees, and motivate employees and retain them. And most organizations may not consider employees as an asset, but employees are a very important asset in any organization, and they are considered as the driving force of any organization, whether it's in the service or the manufacturing industry. How is the environment changing today for human resources? The trends are changing. It's not what we used to do. I mean, just looking at what I've just mentioned, employing and retaining and all those things. we need to appreciate that we are dealing with different trends in the current human resource sector. One of them is globalization, where most organizations are at the global level, serving employees all over the world through sales, through branch offices, and different demographic areas. So the globalization trends, this, as I mentioned, it affects the world economy and other trends. And this has triggered the way human resource functions. So, and their use of HR department has changed because as more companies go global, it means competition, it means more pressure on the HR, on the way of thinking, not just at a local point of view. And also it means changes in the productive and things that are better done by the employees. The other one is the technological changes, which I remember when I was in employment, we faced a lot of resistance when implementing technology in the human resource department, because we knew it was going to give us more efficiency the way we serve employees, and you could communicate anywhere. Like now, during this lockdown time, employees are able to work from home because of technology. And the other trend is the nature of work. It's no longer the routine work that we used to do because jobs are changing due to the new technological changes. There is increase in productivity. Manufacturers produce more with fewer employees. So it is changing the nature of work. And there are non-traditional workers, such as those who hold multiple jobs, part-time employees, and people working at alternative hours or days. We are seeing that now coming into force, because most employees, to decongest their offices, they have to work from home, or they go to the office at alternate days, so that to avoid the crowding. So this it means more jobs are going high tech, meaning employees will have to reduce because, or they should have more skills so that they diversify their areas of operation. And the other change we see is the work demographic trends. We are having what we call now the Generation Y, where they question things. They are not like the old employees where the management talk and that's final. These are generations that question how things are done. And how does this affect? This can affect employee relations in a way, because the management have a way of, they have their regulations, the company has regulations, but here are young people who want to move very fast. And at the end of the day, if you don't listen or give them an ear on their suggestions, it will bring a conflict and disputes within the workforce. And this reveals the reality, the unevenness of the level of understanding between employees and employer. So what are some of there are few things that these conflicts can lead to. It leads to litigation where staff maybe are unlawfully dismissed, or they work in an unsafe environment. There is harassment with holding of salary. These are just a few of the employee problems that are faced by in the hands of especially those employers who are unreasonable. So while a number of employees may know or understand their rights, some of them don't even know which institutions to go to or what procedures to follow when faced with such challenges. So with the new employment law, at least, and the enlightened workforce, it means somebody can be able to read through the Employment Act and know where to go. So that's just a brief of what I wanted to mention today. Thank you.
Okay, thank you so much for those amazing insights. For those who have just joined us, we've had a short session with Ms. Susan Wendot, who's a HR practitioner. She's talked a little bit about the human resource department and some of the conflict issues employees can face, especially during this COVID time when people are working from home. She's also talked a little bit about the conflict issues that employees face, such as termination and also lack of knowledge as to how exactly their issues can be addressed. So I think at this juncture, I'd like to invite Ms. Gladys Wamaitha in order to just take us through the second session. Gladys? Ms. Gladys Wamaitha, can you kindly unmute?
Hello. Good morning, everyone. I'm glad to have this opportunity to speak to my fellow mediators in respect of employment and the new scenario that we have now in respect of COVID-19. My name is Gladys Wamaitha. I'm an advocate of the High Court of Kenya and have practiced law for over 20 years. I'm currently a partner with KMK Advocates. I'm a member of the Law Society of Kenya and serve in the disciplinary committee, and I've been doing so for the past 5 years. I have been undertaking mediation with FIDA Kenya since 2009, and I am an accredited mediator with the Kenyan judiciary since 2016. I'm also a trainer in mediation and a board member with the Law Society Circle Limited. I run a strategic conflict management, which is a company committed to restoring relationships by providing alternative dispute resolution services through mediation and arbitration. Since it's said, a good settlement is better than a lawsuit. Yeah. So I've conducted several mediations, and I'm having a challenge. I've conducted several mediations, and can you hear me? I don't know. Can you hear me?
Yes, we can hear you. Go ahead.
Okay. So I've conducted several mediations, and my slides are not moving. Yeah. Okay. I've conducted several mediations in employment, labor, commercial, civil, land, and family. We also conduct monthly trainings to build the capacity of mediators in their practice. We also have a pool of mediators around the country, like Eldoret, Kisii, Nyeri, Meru, to mention just a few who we work with. Now, the topic today is employment. And there are 7 major sources of law governing employment law in Kenya. There are the Constitution of Kenya in Article 27, which provides for the right to equality and freedom from discrimination. it states that women and men have a right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. Article 27(4) of the Constitution also states that the state shall not discriminate directly or indirectly against any person on any ground, which can be race, sex, marital status, health status, instances of HIV, ethnic or social origin, color, age, disability, religion, conscience, belief, culture, language, or birth. More specifically, Article 41 of the Constitution deals with labor relations, and it states that every person has the right to fair labor practices. Thus, looking at the Constitution, every worker has the right to fair remuneration, reasonable working conditions, to form and join or participate in any activities of a trade union. They can go on strike, and anything that concerns the worker is captured in that particular article. It also provides for the rights of the employer, which are to join and form or join employers' organizations, to also participate in activities and programs of employers' organizations. They also have a right to join a trade union. They also can determine their own administration, programs, and activities. And they can also form and join a federation, like we have the Federation of Employers, FKE. We also have that, and we have COTU for the employees. And for the employers, we have FKE. Now, let's look at the statute that deals with employment. And we have one, which is the Employment Act of 2007, which establishes the minimum terms and conditions of employment. It also establishes the relationship between employer and the employee. It defines the benefits, the duties, the obligations of the employer and the employee, which includes, which is very important, the contract of service. It also prohibits against forced labor. It also specifies about, it talks about discrimination in employment, sexual harassment, payment of salaries and wages, leave, termination, and living amenities. The other statute that deals with employment is the Labor Institution Act of 2007, which works to enhance the institutions and bodies that establish the regulations that govern Kenyan labor relations. This act provides definitions for collective agreement. I think you've heard about CBAs, collective bargaining agreements. So this act governs them. It also talks about contracts of service, employee, employer. It also talks about the trade unions. What about the aspect of redundancy and other pertinent terms embedded within the labor laws? There's also another statute, the Work Injury Benefit Act of 2007. This provides for the International Labour Organization Convention's compliant laws pertaining to the employee compensation in the workplace. You all know that Kenya has ratified the convention, ILO convention. So what the articles in the ILO are also, they can be applied in the Kenyan law. So, and which has also been provided for in the Kenyan Constitution. So following the enactment of this act, many of the sections which, many of the sections of the ILO were also imported into the Kenyan Act. There's also the Labor Relations Act of 2007, which is concerned with the freedom of association of employees and employers and the right to collective bargaining. The Act provides for legal guidelines for the establishment of trade unions and employers' organizations and their functions. That is like FKE. There's also the Occupational Safety and Health Act of 2007. The objective of this act is to provide the legal framework for employers to maintain healthy working conditions and environment for their workers. The act makes provision for the safety and health of all workers in Kenya's workplace and establishes the National Council for Occupational Safety and Health. There's also the Industrial Court Act number 20 of 2011. This is the one that established the Industrial Court, that is which has the same status as the High Court, as indicated in the Constitution of Kenya. The Industrial Court, as established, is a court of superior record. The court has been given powers to adjudicate over cases of employment and labor relations. Now, you've heard me talk about ILO. That is an international convention. So Kenya is a member of the ILO and has ratified a number of important conventions related to the rights of all workers. As a signatory of these conventions, the Kenyan government is legally obligated to ensure that these rights are protected and applied in Kenya. The fundamental rights that are included is the right to form and join a trade union. I think many of you are aware of KOTU and how effective it is. It also includes the right to wages and conditions of employment to a standard set by law and a collective bargaining agreement, which is captured in the convention number 87 and 98. It also gives the right to be free from forced labor, including the right to be free from slavery, forced bondage, and forced labor without pay, as captured in convention number 29 and 105. Now, all these acts govern the labor law. But now we are in a new season, and that is at the season of COVID-19. So what is the impact of COVID-19 on on labor and employment? Now, the coronavirus pandemic has resulted in new government regulations, to thousands of businesses being shut down and unable to continue business as usual. Many businesses have been unable to perform their contracts with vendors, buyers, clients, causing many businesses to breach their commercial contracts or even meet the minimum, making it very difficult and expensive to fulfill their contractual obligations. Undoubtedly, all business establishments, irrespective of their strength and type of industry, have been already affected greatly by the coronavirus pandemic. It is shaking up businesses and consumer behavior on a massive scale. Global travel bans, social distancing measures, which are essential to fight the pandemic, are sharply reducing demand in many key sectors, such as tourism, hospitality, transportation, entertainment, even legal services. Many of us, many advocates can't even practice if their litigation lawyers cannot practice in the court. This means the employers and employees are not able to fulfill their obligations. Now, I just want to give a scenario because I'm talking to colleagues who are my fellow mediators. Just walk with me. I'll give you a scenario of a hotel. take a scenario of an employees in a hotel. We have the sales representatives who have targets which they need to meet. But because due to Corona, they are unable to meet these targets. And the employer will indicate that her portfolio isn't performing. What does the employer do? What does the employee do? She's not meeting her obligations or the targets. The employer cannot be able, because she's not meeting her targets, he's not able to pay her because salary or wages is commensurate to work done. It's catch-22. What about the employer? Let's look at the scenario of an employer. Let's say this taxi service. Let's give an example of a taxi service. The employer has a number of taxis where he has drivers. Due to Corona, business has come down, and in some instances they've been forced to shut down, hence unable to pay his drivers. This employer is caught between a rock and a hard place. He can't, because maybe he has tenders with particular institutions. Does he fire his employees because there's no business and he can't pay them? What happens after Uhuru lifts up the curfew and his clients ask for a vehicle the next day? Where will he get his workforce? Does he employ new people, new drivers? What does he do? And he can't sustain them. At the same time, he can't sustain them because there's no business. So there's this now catch-22 situation for the employer. Let's look at another example of the security services. Every mall you've entered or any building that you have entered in Nairobi, any hotel, they always have security guards. But due to Corona, some hotels have closed, some offices have closed. So there's no need of the number of security guards that they were employing before. So what happens to this security service? Does he, where, let's say in a hotel, he was offering 35 guards, but because now the hotel has been shut down, they only require 3 guards. What does he do with the 32 guards? Because now business has reduced. So does he send them on leave with pay, without pay? Does he terminate their services? Does he render them redundant? What happens? And let's take the scenario of what is now currently being discussed about schools. If, let's say, this employer, this business person undertakes business, runs a school, what happens? There are no students. Now there's virtual learning. Which teachers, let's say a subject had 3 teachers, which teacher remains and which one goes? Does the owner of that business continue paying all the teachers, or does he pay some? How that balancing act? Now, as mediators, what disputes arise in respect of these various scenarios that I've given you? Many cases might come before you in the issue of discrimination. Why did that employer choose those in the security service? Why did he choose those 3 as opposed to any other 3? Why these particular teachers and not these other teachers? Why is the hotel employee, the sales representative, being rendered redundant as opposed to maybe being allowed to go on leave without pay. The issue of discrimination arises. What about the contracts? Does an employee go with leave without pay? Is he rendered redundant? Is he terminated? What are the employment particulars? They are contained in the contract. The employer is varying the terms of the contract. What's the middle ground? Now that's the thing that now mediators have to start thinking about. How are you going to deal with these types of mediations that come before you, that where they bring up the issue of violation of rights on the grounds of discrimination, the breach of contract. How are you going to deal with those mediations where you have to meet that middle ground of the employer and the employee? What about the CBAs that we are talking about, collective bargaining agreements, where an employee is a member of a trade union, and before COVID, the trade union had entered into an agreement with the employer that maybe termination, as in the case of hotels, you must give 3 months notice. Now we are in Corona. If an employer decides they want to terminate the services of an employee, how do they apply the 3 months notice? Would they be violating the terms of the collective bargaining agreement? Now, there's another scenario where the employer maintains the employee, sends them on leave without pay, but is meeting the statutory, paying the statutory deductions to the government during this pandemic period. What happens? Because now that goes to the very nature of the contract of service. Why should the employer just pay statutory deductions and not pay minimum wage? These are the different case disputes that might be brought before the mediator. You need to start thinking about it. Now, there is a laid-down procedure of terminating employment of an employee. And that can be the actual termination on specific grounds, redundancy, there could be the resignation of the worker, or death of the worker. And the law says that termination of an employee by the services of an employee by an employer, the span of time must be adhered to in order to complete a lawful termination of work. Now, the notice period is dependent on the duration of the pay. Now, you as mediators, you must think about that in the back of your mind, that what is the notice period that should have been given in respect of this particular dispute. Because if one is paid on a weekly basis, then the notice is 1 week. If he's paid on a monthly basis, then the notice period should be also 1 month, unless there's the contract of service says otherwise. Now, an employer cannot dismiss or terminate the employment of an employee without good cause. Yeah, and that good cause must be substantiated. And even if there's prolonged illness, there has to be a balance in how that long illness is. Is it diabetes? Is it high blood pressure? Which the person can continue working. Is it HIV? If somebody is being discriminated on the grounds of HIV, then that's violation of the rights. when an employee is going to be terminated, he's entitled to receive his terminal benefits and any contributions to a provident fund. Now, the employee can also choose to stop working, and he just needs to give notice, adequate notice as per the contract of service. There's also some summary dismissal. That's like some companies, maybe some have decided there's corona, no business. All of you go home. I can't pay you. That's some form of the summary dismissal. But the employer cannot do that because there has to be, the law says there has to be gross misconduct. So if you get this kind of disputes, have it in the back of your mind that summary dismissal has a procedure. That gross misconduct is absence from work without permission or lawful cause. Gross misconduct also includes being drunk in the workplace. Gross misconduct is willfully neglecting to perform any assigned work. Gross misconduct is use of abusive or insulting language or behavior in the workplace. Gross misconduct is knowingly failing to obey a lawful and proper command that is within the scope of employment. Also, if an employee is arrested for a crime which is punishable by imprisonment and the person is not released within 14 days, that would amount to summary dismissal. Now, during this COVID period, if an employer decides to dismiss or terminate the services of an employee without obeying the law, then you as the mediator have to know. A mediation cannot proceed where points of law have been brought up. That should go to the court of law because the court has to make a decision on that point of law. What about redundancy? I conducted a webinar on how to mediate breach of contracts during this COVID season. And there were numerous questions in respect of redundancy. Can an employer take their employee terminate their services on the grounds of redundancy? One point that I wish to bring to my fellow mediators is that in the case of redundancy, the employer must follow the procedure set down by the law, and it's very, very clear in the Employment Act. The employer must inform the workers' union or the labor office in the area and must give the reasons for redundancy. The employer cannot just wake up one morning and decide, all of you, I don't have business, so there's no income to pay you. I've terminated your services on the grounds of redundancy. You as the mediator must know that, one, there must be a notice. And why is he taking that employee? Why is he terminating on the grounds of redundancy? Those matters must be in the back of your mind. And a redundant worker shall be paid in lieu of his leave, and he shall also be entitled to 1 month's notice or 1 month's wages in lieu of notice. The redundant employee is also entitled to severance pay. So if you have that kind of dispute, ensure that those things have been met, that all the payments or benefits due to that employee have been met. Now we have the court, which has been established under the Industrial Court Act number 20 of 2011. Now, it revamped the Industrial Court, that is the same status of the High Court as provided by the Constitution of Kenya. The Industrial Court, as I said, is a superior court and has the powers to adjudicate over all cases of employment and labor relations. That is the employer, employee, employers, organizations, and trade unions. Now, their disputes are filed in the registry of the court and is headed by the registrar. Now, when a dispute is taken to the industrial court, there are two parties. There's the claimant who files the case and the respondent who defends the case. The claimant will institute a claim in the industrial court by filing a statement of claim or a memorandum of claim. Now, the memorandum or statement of claim outlines the particulars of the parties and the reason for the cause of action. It sets out the grievances, any attempts to settlement, and submissions of the parties, prayers being sought from the industrial court. The memorandum and statement of claim must be accompanied by a verifying affidavit sworn by the complainant before a commissioner of oath and must be attached with any supporting documents that the claimant wishes to rely on. Now, the respondent must be served with this memorandum or statement of claim and given the opportunity to respond. And the respondent will be required to file a reply to the memorandum or statement of claim upon service. The respondent must also respond to the grievances and include submissions and supporting documents that he wishes to rely on for the dismissal of the claim. Once the respondent has filed the response, they are required to take a date for directions before the judge of the industrial court. On that date, the judge shall confirm that all the documents are in order and give directions on whether there's a case and how the case is going to proceed for hearing. The judge can order that the case proceed for hearing in another town, so long as the court is able to hold sittings there. Let's say the claimant comes from where? Let's give an example, Kisumu. And he was working in Nairobi, in one of the industrial area, but he files the claim in Kisumu, Employment and Labor Court in Kisumu. The judge, since the respondent is in Nairobi, the judge can order that the claim is transferred to Nairobi and it proceeds there. Or the claim could be filed in Nairobi, and the judge says, since the jurisdiction of the claimant is in Kisumu, the suit should proceed in Kisumu. Now, once a hearing date is taken, the parties shall be allowed to call their witnesses on that date. After oral evidence is taken by the judge, the parties will be given their final submission. Then the judge will deliver his judgment. Now, in this particular court, the employee an employer can self-represent. It's not mandatory that they should have advocates. Also, a trade union representative or an employer's organization is allowed to appear before the industrial court on behalf of the employee or employer, respectively. On the other hand, an employer and employee are at liberty to appear in person or hire the services of an advocate if they want. Now, upon hearing a dispute, the industrial court can make awards for damages, compensation, order of declaration, a reinstatement of an employee, injunctions, among others. If a person is aggrieved by a decision of the industrial court, a right of appeal lies in the Court of Appeal. Now, what what documents are prepared to be taken to court? There's the filing of the memorandum of claim or statement of claim, which has the supporting documents. There's some courts want you to list the witnesses that the parties are going to bring. There's the reply to the memorandum of claim. Now, the cost of filing these pleadings, we call them pleadings, is roughly between 0 to 5, because sometimes a claimant can not be charged. So it could be 0 to 500. Then there's the respondent must be served, and that is through service of summons, which could cost about 5,000 shillings for the service of those summons. There's the taking of directions before the judge, which some courts charge like 325 shillings for taking that date. Then there's now the fixing of the hearing date, which is free. And and payment for legal fees if an advocate is being involved could be between 30% of the award or the damages that he's offered to maybe 200,000. Now, why I've brought up the issue of the cost is to compare the cost of undertaking litigation in court, taking a dispute to court, and vis-a-vis undertaking mediation. As you see, if a party opts to take mediation, it is much, much cheaper because one, you will only pay maybe for the room that you're going to undertake the mediation. If you're taking the mediation in court, it is free. And your services, just how much are you going to charge for your services? So litigation vis-a-vis mediation will be much, much cheaper. What about the duration of taking a dispute to court? It would take roughly 1 to 3 years to finalize a dispute at the Employment and Labor Court. But through mediation, if we take what the judiciary has stipulated, it can take 60 days. So 3 years and 60 days. So parties should opt for mediation because it's a quicker way of settling disputes, and also you can restore relationship. Now, mediators always should remember the purpose of mediation. Mediation is the intervention in a negotiation or conflict. It also addresses substantial issues. It will strengthen relationships. It calls for parties to work together with the aid of a neutral facilitator. The role of the mediator is facilitative, and restoration of the dispute rests with the parties. That means the mediator works to reconcile the competing parties. In spite of these trying times, undergoing mediation can potentially enable businesses and individuals to mitigate their losses and strengthen long-standing relationships. And parties should be encouraged to take up mediation. Now, what tips do I have to my fellow mediators when you're undertaking these mediations during this period or after COVID? Because I know there will be very, very many mediation cases that will be brought because of either the employer did not conform with the Employment Act or the other acts which govern employment and labor, or the employees failed to fulfill their obligations to the employer during this period. You, as the mediator, should provide knowledge and information. You should use more effective negotiation processes, thereby helping the participants to settle contested issues. You don't have authoritative power to give a decision. So make sure you don't force the parties to resolve their differences and enforce a decision which maybe the parties are not willing to. Remember that you're the problem explorer and solver. Enable the parties in dispute to examine the problem from a variety of viewpoints. Assist in defining basic issues and interests and look for mutually satisfactory options. Help build a reasonable and implementable settlement, and question and challenge parties who have extreme and unrealistic goals. Take the initiative to move the negotiations forward by procedural or occasion substantive suggestions. I remind you, it's suggestions. Assist in open communication and negotiations, open communication channels, or facilitate better communication if the parties are already talking. Assist the parties find overlap in their bargaining positions or encourage concessions. Help all parties recognize the right of others to be involved in the negotiation. Transform these disputes by allowing the parties to develop a fresh insight into the issues and their positions and opening up to creative avenues for settlement. And with that, I hope that you will be able to conduct your mediations well. Thank you very much.
Okay, thank you so much, Ms. Wamaitha. That has been a really good session. We're very, very thankful for you for joining us today and just for sharing your thoughts on this particular topic. So I think at this juncture, I'd like to invite Mr. Rashid Wiza, to just give us his thoughts, some commentaries on the session as a whole, and also just what are his thoughts in terms of social, political, and legal aspects in the employment and labor relations sector. Rashid? Rashid, are you here with us? Okay, as we wait and see if, okay, Rashid, you're ready? Oh, okay, go ahead.
Thank you. Good morning. And I'd like to say Ms. Wamaitha has taken us through a very comprehensive discussion on the employment aspects and how we can tackle employment disputes that arise I can say that I'm very thankful for the presentation that she has given us, as it has been systematic, having taken us through the legal framework, the various scenarios, and the issues on summary dismissal, how as mediators we can be able to identify. Sorry, my video is not cooperating. How as mediators we are able to identify the rights of the parties and to help them arrive at solutions that might be of benefit to both of them. And she has clearly talked about issues of redundancy, where she has insisted that the employer must inform the workers' union and must give reasons for the redundancy, because this is captured in law. And as a mediator, it is your duty to know that there must be a notice, or rather payments that are due to any of the parties must have been met. Also, she talked about the industrial court, which is involved in issues of employment and labor relations. And she said that disputes there are headed by the registrar, and usually the parties are claimants and respondents. Usually there are timelines that are observed during filing of cases in the Employment and Labor Relations Court or the Industrial Court, and both parties are given sufficient time to respond to the claim that is before them, and then the court gives directions where the judge then confirms whether the case can proceed, or where there is a contested issue of jurisdiction, or where jurisdiction is in question, the honorable judge might, or the honorable registrar, or rather the court, can identify the court with the right or the correct jurisdiction. Another thing that, just to summarize on what Ms. Wamaitha said, is that parties are usually at liberty to appear in court, either as themselves or through their advocates or representatives, and they can, and other people who would like to be parties, or rather are interested to the outcome of that dispute, or to support one party, are welcome. Also, she gave us most likely outcomes that the court can order, and she said an injunction is likely, or any order that is sought by the parties through the prayers is likely to be issued, and that an aggrieved party has a right to appeal. And usually in industrial courts, there is costs that come with the filing systems, the filing process up to the end of the dispute, where then she later brought to us a clear perspective of viewing mediation as a cheaper, or rather a cost-effective avenue compared to the court process that most people who don't know the existence of mediation, or that the awareness is very little, tend not to explore this option. She has also told us that mediation saves time, and it is an expeditious opportunity for the parties in dispute to quickly resolve their dispute. And it is also supported by Article 159 of our Constitution, which highlights the overriding objectives that the courts, courts or judicial has the judicial authority to ensure that disputes are solved in an expeditious manner and through alternative means where possible. Also, she highlighted that we should focus on how relationships can be restored in the mediation, because as mediators, we should envision parties getting along after that mediation, and that the parties have to maintain a strong relationship, in as much as it is not part of your, it is not your role to make sure the parties agree, but you ensure that their relationship does not get worse because they came to mediation. Just make sure the parties are looking at their interests and how well they can manage their differences to arrive at a more amicable solution or at a better place than how they came in your mediation chamber. So finally, she highlighted that we should use more of our negotiative skills, and we should not force parties to agree, and also that parties should be helped to see their best alternatives, what could be worse, and likely what could be the most likely alternative to their agreement. She said that parties should open up to avenues to settle their disputes more amicably, rather than leaving the parties on a very difficult way or at a difficult position in their dispute, that they are unable to see what can be achieved through mediation. Perhaps because of whatever I've been doing here, where I am, maybe I failed to capture some few things, but I think I caught a few very important points, and I've learned a lot from Miss Wamaitha, and I look forward to learning more from the rest. You also, Miss Amanda, you also wanted me to touch on social political, I believe.
Yeah, you can just talk about it briefly.
Okay, I was more concerned about the socio-economic aspects, because with social political, it's usually I usually look at the political impact of COVID-19, which is very unpredictable, because politicians are very manipulative, and they will use any available laws to favor themselves. As we can see now, there is a shift in the political arena. The politicians are trying their best to save their political careers by shifting to whatever party that makes them look good or saves their political futures. But in the socio-economic perspective, I see that, as highlighted under Article 43 of the Constitution, the rights, the socio-economic rights of the people have been diversely affected, and there is an opportunity to see that conflicts involving landlords and tenants are on the spike, and issues of the government's efforts to make sure that the national government and the county government, its efforts in ensuring that its citizens are provided with the basic social rights and opportunities to come up with income generating activities and a daily bread are affected. It has become a challenge to the ordinary mwananchi to do business and feed their families, and it is evident in our several counties that mediation is now something that you cannot avoid, because these people are ready to go anywhere to get justice, but unfortunately they do not believe they will get that justice. So as a personal initiative, I decided to do pro bono mediations, or at a very reasonable fee here in Kwale County, to help parties in disputes, both landlord and tenants, and those in family disputes, to amicably solve their disputes and to see a long-lasting solution despite the presence of COVID-19. I think with that impromptu opportunity, I've been able to catch or grasp a few points that I shared with you, and I hope they are of benefit to the rest. Back to you, Amanda.
Okay, thank you so much. I think Rashid has been able to capture a couple, if not a majority of what Ms. Wamaitha has been able to share with us today. Thank you so much for taking up the opportunity to make a short commentary. I think also one of the things I've noted that Ms. Wamaitha has been able to share with us is concerning the COVID-19 period and what changes exactly we are expecting to see, the conflicts that are going to be coming up, and what opportunities we can actually take up as mediators. Some of us here are very young mediators, and we can just be able to kind of resolve and restore the relationships within within the communities and within these employer-employee relations. And at this point, it's really kind of a push and pull, because everyone is trying to reserve their employment opportunities as well as their business survival. So it's really about balancing the interests of both parties and trying to be able to get an amicable solution for both sides. So I'm seeing some questions in the chat and also some comments. So I will just highlight. I'll start with the questions and direct them straight away to Ms. Gladys Wamaitha. So one of the questions is from Lily Miner, and she's asking, how do the provisions on labor relations in the proposed pandemic response bill influence mediation? And the second question is from Susan Wendot, and she's asking, how can one initiate mediation process where an employee is filing for wrongful dismissal from service? So maybe Ms. Gladys, you can be able to take us through those questions. Sorry.
So I'll take up the first question by Lily Miner. There's the Pandemic Response Bill of 2020, and Section 30 of the proposed bill deals with the labor relations. And it states that the employer shall not terminate a contract of service and dismiss an employee. 2, an employer shall not coerce an employee to take salary cuts. An employer who is unable to pay salaries shall permit an employee to take leave of absence without pay for the duration of the pandemic. That's what the proposed bill stipulates. Now, as mediators, I would like you to look at the wording of this proposed bill. It's in mandatory terms. Shall not terminate a contract of service. But look at this bill vis-a-vis the Employment Act. An employer and an employee are governed by the terms of the contract of service. And the contract of service and the terms in the contract of service cannot be varied without the consent of each of the parties. The Employment Act is very specific and says that if any party is going to vary or change or amend the terms of the contract, the party must be called and they have a discussion and agree on what terms are going to be amended or varied. During this COVID period, if an employee is to terminate or vary any terms of that contract, it is prudent and it is mandatory that the employer calls the employee for a meeting or calls all his schedules a meeting where there's an agenda, and the agenda stipulates what they are going to discuss in that particular meeting, and allows the parties or the employees to give their proposal of how their contract of service is going to be varied during this period. Yeah, so then it is mutual. There's negotiations between the employer and the employee that even as they leave that meeting, everybody has agreed to the way forward. If they agree to go on leave without pay, so be it. It's the employees who have agreed and determined who's going to go on leave without pay, who's going to go with leave with pay. The other employee, the employees themselves can also decide who's going to work virtually and who's going to not work at all. So let there be communication between employer and employee. Now, what I foresee is that many employers, because they didn't take into consideration the provisions of the Act, there are going to be very many legal suits. And maybe the court, through the court annex mediation, will engage many of the mediators to mediate those matters because the employer didn't follow the law. So based on that, I think mediation will play a very big role because, and should be part of the process before the matter goes for litigation. Because now this is where the parties negotiate the situation and bring the issues before the table. You didn't conform with the law, or these circumstances were prevailing. How do we mitigate this position? And how do we continue with the relationship? And because now, the other scenario is the employer cannot pay the employee. Yeah, but let it be the employee saying, I understand the situation, I'm willing to go without pay, but it should be by consent. Now, I'm talking about how many litigation cases are going to be filed, or there are going to be very many disputes because of non-conformance with the law. How do you initiate? Susan has asked, how do we initiate the mediation process? Let's say an employee comes to you. That's his dispute, and he knows the advantages of mediation, knows that it will take a very short time. It's even much cheaper. What do you do as a mediator? Why don't you take up first as the mediator? You have to ensure that there's no legal issue that dispute brings up, because you as a mediator cannot deal with the legal issues. That has to be determined by court. Let me just give you an example of a legal issue. But this one is not employer-employee, but I think it's a very, very good illustration. I'll take it from the family mediation, where a man has 3 wives. He has two wives. Okay, he has 3 women. 2 are legal. Okay, 2 are known. Then there's a 3rd one who are known by a few friends. The gentleman dies. The 3rd one who's known by a few claims to be a wife. So 3 women, 2 know each other as the wives and are known in the community as the wife. But there's this 3rd one who's known by a few and maybe even has a child of the deceased. Can that dispute be settled through mediation? In my opinion, it can't, because you as a mediator cannot determine whether or not the 3rd lady is a wife, and that is a legal issue, and it should be determined by a judge, a court of law, whether the 3rd lady was actually a wife or not before the distribution of the properties can be done. So That's what I meant by, if a dispute brings up a legal issue, then it's better that it's handled by the court. So if you've done the screening, because you all know as mediators, like if you're connected to the court and next mediation, you know that all the matters that are filed in court go through screening. That screening determines whether or not a dispute raises an issue of law or not. If it doesn't raise any issue of law, then it goes for mediation. And that's when you're appointed as a mediator to mediate that particular dispute. So you as a mediator, in your private capacity, somebody approaches you. I conducted a training on screening for mediators. I do monthly talks for mediators to capacity build them in respect of their practice in mediation. And last year I had a talk on how do you screen disputes that come to you, to your practice, to know whether or not to proceed with the mediation. Screen the dispute and see, can I handle this mediation? If I can, send a notice to the other party, informing them that Mr. X approached me, I am a mediator. You introduce yourself first. Tell them that you're a mediator and your qualifications, and that Mr. Person X approached you with this dispute, and they are willing to undertake mediation. Invite the other party to the mediation process. Give them time. And if there's no response, send another reminder, inviting them to come to your offices and see whether you can mediate, to undertake the dispute through mediation. Most of the people, most respondents are usually willing to undertake the mediation, especially if you explain to them the advantages of mediation. And if both parties, if the respondent consents to the mediation, proceed with your mediation. So that's how I would initiate a mediation if somebody approached me at this juncture. Yeah, but I think it is very important that you screen that mediation, that dispute, and ensure that you can undertake that mediation, so that at the end of it you have results and that you restore relationships, and not go through the process and it doesn't work out. Yeah.
Okay, thank you so much. I'm seeing here in the comments, both Lily and Susan are saying that they have they're well answered and they're thankful for the elaborate feedback. Maybe just to recap on a few of the comments that have been raised. I'm seeing Patricia Okech has said that it's a great session and it's a wonderful idea to have a whole day's symposium. Wangari Kabiru also adds that it's empowering to have having senior mediator advocate Wamaitha, HR expert mediator and HR expert mediator on the same platform with our young mediators, YMM Rashid, YM myself, and others. And we are thankful for you joining us today. I think the others are additional points, but all in all, thank you so much to both our speakers, Ms. Susan Wendot and Ms. Gladys Wamaitha, for joining us today. We are extremely grateful and we are thankful for all the insights we've been able to share together. I think we should continue engaging even in our respective mediation groups. I hope all of us are part of a forum of the sort, and we can be able to engage on these matters and be able to share and learn as much as possible in terms of the employment sector, because these are things we are likely to see as Ms. Gladys has put it, these are things that we are going to see quite a number of suits, and there'll be a lot of mediations in the employment and labor relations sector. So it's good for us to be knowledgeable about the law and the social issues regarding that, and we can be able to be better mediators, and we can be able to also help those who are facing conflict. So at this juncture, I'd just like to say thank you to everyone for joining us today. Thank you for joining this particular platform. And in about a few minutes, we'll be going on to the second session, which is in the mining industry sector. And it's in the mining industry technical knowledge, and we'll have a couple of speakers talking to us later on. So I'd like at this juncture to thank you all, and stay tuned. Don't leave the group just yet. And I'll turn it over to maybe to Wangari Kabiru to maybe take us through the last part, the vote of thanks. Thank you.
Thank you very much, Amanda. And I am delighted, as we also just have mentioned, that we have a full day. Yes, we do have a full day of sessions running, as you see that in the afternoon, which is at 4 p.m. we have Honorable Moses Wanjala, the Magistrate and Registrar of the Mediation Accreditation Committee in the Office of the Chief Justice and the Judiciary of Kenya. He's joining us on a discussion on family wealth mediation, the question that we're asking, and it's a question that we have been asking, and in 2020 we are unraveling this question by hook, by crook. The question is succession a success in Kenya? So we'll be having the Judiciary of Kenya perspective. As Wasilianahub, we initiated with the members of the team, and of which our speaker today, Susan Wendot, is actually the team lead. We initiated the Family Wealth Mediation Committee of Practice, and in it already we started off our research, and we have been able to carry out the first phase of the research, which was engaging with people who observe based on age what happens in the area of inheritance and succession in Kenya. That was in the age group of 25 heading on to just about 40. We have 3 other age brackets to also engage with, and then we can be able to have a comprehensive risk report together with also engaging administrators and other people who are also in this work, which includes the judiciary itself, and that's why we are having this discussion with the judiciary. In addition to that, as you are probably informed or you anticipate now that we have a good day that's ahead of us together, we have the next session that is coming right away, which is with engineer Dr. Muchiri, who is a mining engineer. And we are some of the luckiest people because Dr. Muchiri is actually the first PhD in mining, in Kenya. And the exciting thing is that we are actually having a masterclass with him for him to take us through the technical aspects of, for him to take us through the technical aspects and help us to start understanding what happens in step by step in the mining field. And it's because this is the area of extractives, which covers mining, oil and gas, and plus other areas of exploration. This is an area of interest for Wasilianahub, and we have a working group that is looking at how we can be able to bring in professional mediation within such a high stakes sector. So Dr. Muchiri, who is already on the call, thank you very much for joining us. I'd like to thank you, Amanda, for moderating this session. I know you're rolling into the next session to moderate. Colleagues who on the call, please hold on. We probably have just 1 minute, and then our moderator, Amanda, can be able to start us off on the next session. So thank you, and it's a delight. Please remember to share with your various groups these sessions that we are running with. The link that you have for accessing is a free access link for the whole day today. We will be taking a break after Dr. Muchiri's session and coming back at 2 p.m. where we will be having Mr. Lawrence Mwiruri Ngugi of the Nairobi Center for International Arbitration. He will be taking us through a very important convention. It is the Singapore Convention on Mediation, which is a United Nations convention. And then also in part 2 of that discussion, he will be telling us what is the NCIA for. mediators. How can mediators engage with the Nairobi Center for International Arbitration, and also give us insights on what's probably happening on the ADR policy as best as can be done. So back to you, Amanda, and thank you very much, colleagues. So, ladies and gentlemen, please grab your glass of water, and we will start off at exactly 11:30, which is in the next 2 minutes, kindly. Thank you very much.
Okay, thank you everyone for staying tuned. So our second session for our third session actually for the day, we'll be looking at mining industry technical knowledge. It will be a masterclass, and Dr. Muchiri will be our main speaker for today, and he'll be taking us through the steps in the mining process. So let me just start by giving a general overview of what the session is all about. So first of all, we will have a short commentary by Mr. Rashid Mriza, who is a young mediator. He's just spoken in the last session as well. So he'll be giving a commentary on the role of non-technical practitioners, experiences serving in the mining communities in Kenya, and he will contextualize it to where exactly he has been carrying out these mediations, and he'll be able to give us an insight on his experiences from the coastal region. Our main speaker will be Dr. Muchiri Githiria, who is an engineer and a researcher and works at the at Taita Taveta University. So he'll be looking at mining exploration, and that will be the main topic of today, and he'll be taking us through the steps in the mining process. Lastly, we will have a commentary in the last session, and it will be by whoever will feel ready to share the experiences. We will have you speak on the same, and we'll also expect Constance Terry, a young mediator as well, to also share her thoughts on the same. Yes, so those will be our speakers for today, and at this juncture I would like to invite Rashid to start us off with his short commentary. Rashid?
Hello, good morning again. Now, I am from Kwale County, and Kwale County, apart from tourism, is well known about its mineral composition. Kwale County is rich in titanium and other minerals like niobium and some other minerals that only base titanium and its close companies that it relates with know. But the emergence of Kwale as a mining sector has brought an unforeseen an ongoing dispute that is not likely to end any soon. Maybe because of the reaction of the government and the mining company to the pleas of the local communities. Now, base titanium and it's okay, I can just say base titanium because that is the company that I know. Base titanium managed to identify Kwale County as the potential area to explore and to exploit its mineral composition. And luckily or unluckily or unfortunately, it has been a good move for the government to earn revenue through the mining licenses and the other charges that the base titanium is paying to the government as revenue and as compensation for the activities that it is doing to the community. Now, the community has been affected by loss of land. They have lost their land, whose economic activity was farming, agricultural practices, and also holding it as ancestral land for the future generations. Now they have lost this land to base titanium, which the question of compensation came. Now there have been disputes between the national government and the local community, and between the national government and between the county government and the mining company, that is base titanium, and also the conflict between the community members and amongst themselves, some of which are pro-base titanium and some are against base titanium. Now, I'll just give you an overview of Kwale because I am more familiar with Kwale. So you'll forgive me, I cannot talk about Redundancy, where diatomite is mined. So I cannot, but the problems, they should be the same, that there is usually displacement of people as more and more exploration is done and more mining more minerals are discovered. So the Kwale community has been a victim of these mining activities. They have lost huge chunks of land. Communities and villages have been displaced, and the compensation has not been adequate. So the main dispute in Kwale is the issue of compensation. The second dispute is in what do they get what share do they get from base titanium's explorations in Kwale? So for the amount of profit that base titanium makes, the Kwale citizens demanded a reasonable profit profit percentage from the total profit that Base Titanium makes. And I can say that there was developed a community development agreement, which is an agreement between the mining company and the community to come up with an agreement on what percentage profit can the Kwale community benefit from the total profit that Base Titanium makes in the mining, the minerals that they are exploring in Kwale. And so with this community development agreement, there is some hope that the Kwale people envision that they are going to get some benefit of the beautiful minerals that are being discovered, that are being mined in their ancestral lands, and that there might be actually more focus in future about how adequate is their compensation, because they still cry about the compensation that they received. Some have lost huge acres of land for thousands, and not even tens of thousands, but thousands. So it is painful, it is a reality, and it is something that the law has to come in place. And also where communities are fighting amongst themselves, then the mediators there can come in place to mediate and to help them understand that they are either in the same battle, or they're supposed to make sure that their disputes are managed well for the future of Kwale and for the future of the mining activities that are happening there in Kwale. Maybe that can be my commentary, and I hope it is well understood. Back to you, Amanda.
Thank you so much for that short commentary. I think at this juncture, I'll just go ahead and invite Dr. Muchiri to take us through the session. Dr. Muchiri. Dr. Muchiri, we can't hear you speak. Have you connected to your device, to the audio?
Hello.
Yes, we can now hear you. Yes.
Oh, technology issues. All right. Good morning again. I'm hoping that can be heard by everyone. My name is Dr. Muchiri, as Amanda has introduced me. I don't need to introduce myself again, given my whole CV. I'll go straight to whatever we're supposed to do. And I don't know if it's a masterclass or just a talk that we're having, because I'll not get into the nitty-gritties of everything that I might mention. It's just the basics that if I'm asked what is mining, what happens in mining industry, then I can say some things which anyone will understand. So I'm glad Rashid said something about Kwale, because everyone is talking about base titanium, and it's one of the biggest mine that we have, which in other countries is one of the smallest. If you compare with whatever they're doing, I would say they're Australia, Canada, America, South Africa. they're really good in mining. One of the biggest sector that is supporting their economy in terms of the GDP. But the thing is, they're doing it right, where they have other supporting industries being supported by mining, either in manufacturing, either in agriculture. You find all these countries are really good in other sectors. Like, for example, Australia and South Africa, they're really good in beef farming. So being supported by mining industry, they have the money to do all the things that they can do. And manufacturing coming to it. They have all the Toyota cars or any other assembly plants they have there. So you can see that. So there's another thing. So I'm thanking Rashid that he mentioned Kwale, because there are 3 areas that I thought of to highlight. He talked about the socio-environmental aspect in the mining sector, which he mentioned by case studies of the guys who lost their land to the mining activities. So where I come through looking at mining as a positive thing for the industry, for the country itself, for the GDP and everything else. But we need to do all these things right. Having everything that you do being studied, using a feasibility study to check, is it the socio-environmental aspect, the economical aspect, that's the mineral economics aspect, the mining politics that we have, either in the stakeholders, the 3 stakeholders, the major stakeholders, that is the government, the mining companies, and the communities. They all benefit who are having this mineral that we have down there. So to start off, I just wanted to mention where it's a really good aspect to check on what is happening in Kwale, and we do it better in coal mining, because I'm for mining the coal itself, but that's another topic for discussion. Whether it is gold in the Western area, what can we do better? For example, whatever the Tanzanians people are doing in terms of the technical aspect, they're doing really, really good. The only aspect is the royalties, the mineral economics side is not good. The country is not benefited as much through the mining industry as it will be if it's another country. For example, the 4 countries I've mentioned, South Africa, Australia, and Canada, and America. So coming to mining, I just need to jump on that. So sorry if I lost you on that. Coming to mining, the 3 areas I mentioned even earlier, where we have artisanal, small scale, or large scale, that is in the size of the mine itself. Either the 3 you're doing, either artisanal, you're doing for leisure, or you don't have the economics to grow it to a small scale, or the economics or for a small scale to go to a large scale. So the artisanal miners will have either it's about the money, or you're just doing for leisure. Because I've seen in Australia, people just go and do it for leisure, having their detector go out there, trying to do something in the field. While in Africa, most of the mining industries have really big artisanal mining industry, which is one thing which is one of the topics that most of the conference will be talking about. How can we formalize the whole industry so that we can benefit out of it? Congo is trying to do that, because a lot of gold coming out of Congo informally. How can we formalize that? And that's what they're doing. They're really doing a good job. If you can check how they get the gold from the mine itself, package it, have a certificate and all that. Those Zurura or Zamazama people in Congo are doing it right now. Having a CBO, community-based organizations, so that they can form artisanal miners, combining themselves, making it looking like a small-scale mine. Then the large scale, we have them in other countries. I don't think we have a large scale. We can call base titanium as a large scale in our country, because we don't have something bigger than that. So there are 4 aspects that we look at when it comes to mining. That is exploration, exploitation or mining or extraction. That is the second one. Third one is processing or beneficiation. And then the last one is either refining and marketing, both or either. So you first explore. That's what I'll use base titanium as an example as well. That was what Tiomin before base titanium was doing. It did an exploration out of the whole mine itself, valued the mine. So by valuing the mine, they had to do a feasibility study. For any project, engineering mostly, or any other project, you have to do a feasibility study to show how feasible the mine it is. By valuing the mine itself and looking at the technical aspects of everything, even the social aspects as well, the environmental aspects. So that's where the EIAs comes and the management systems, the EMS, which NEMA requires you to have in that feasibility study so that they can endorse, all the authorities, the government authorities can endorse the mining license. So you have an exploration license, which takes a lot of money. That's where Tiomin did something and then he sold the license itself, not the mine, the license, because there was no mine then. The license showing the indicators of what is down there. That is the geology of the ore deposits. So we have geologists and surveyors and engineers taking and modeling an ore deposit. Ore is the mineral itself. Modeling all that, and the ore deposit can be coming into 2 forms, either a hard rock, simple as that, or a soft rock. So the hard rocks are the ones that you call gold, metals, precious metals, all these things, iron ore, copper. Yeah, and the soft rock is a coal, limestone. Then we mine these things differently from what happens in hard rock. You have equipments for that. And that's what the Germans are really good at, the machinery. So they build the machinery for the Australians and the South Africans to either mine the coal itself, because some mines you don't need to drill and blast, because coal, the way the geology behind it, if you can Google how coal is mined, you have big machines which rotate and cuts the coal itself and take it outside. So that's different from hard rock, where you drill and then blast. Then you can take the material outside using trucks and shovels. So then you come to where you've gotten the model, the ore body model down there. You're just trying to imagine whatever that is there using the science that we have. Then you come to now do the mining itself, because you know there's money out of it, because you've valued the mine. So you come do excavation and you handle the material. That's where I say the drilling and the loading. Either you drill and blast or you cut itself, depending on the type of the rock you have, either hard rock or soft rock. But that is as simple as saying hard rock and soft, but there's the science or the geology behind the hard rock and soft rock, different minerals, different rock formations. If you go back to our geography in primary and high school. Then you come to the last step, which is processing, beneficiation. So beneficiation, I use that word because in gemstones, you just cut. So that's beneficiation of that mineral itself. You just cut and that's it. The gemstones, diamonds, by cutting and looking good, and that's it. But other minerals where you have gold, you have silver, you have iron, you have copper, you have every other mineral that you have to process it to get the mineral itself, to remove the impurities and get the mineral itself, by either taking it through hydrometallurgy or pyrometallurgy. I'm not an expert in metallurgical engineering, but either you use water or use heat to transfer, to get the impurities out. After getting the mineral itself, then you refine, and that is gold. I was looking at gold. You refine and get it to the market. So that's like if you're looking at gemstones after beneficiation, then you market the gemstone itself. So there's markets which are set up in the world. you have the London Stock Exchange, you have America, what they do there, and other countries. So that's one, all these areas, when we're even talking about mining, we need to see what can we do. Can we do exploration properly? Yes, we can, with the right technology and all that. Can we do mining itself, the extraction of the mineral itself down there, drill and blast? We've been doing that properly, economically, minimizing every thing you have like cost or danger or hazards. We can do that properly. Cement companies doing that in big scale. Gypsum, you have minerals everywhere in the country, and we're doing that. The processing and the beneficial is that problem where we can't do to the final stage, and that's where every other regime, or no, we have maybe two regimes who have been talking about this. The Michiri, after Michiri, and other ministers have been emphasizing on beneficiation of that mineral itself. You can't take gold, which is unrefined, outside before you refine it. So that's something else to talk about. So there's politics to that, there's economics and all that. Then you market and then you get your profits. Then you go back to the 5 initial stage. So using that, that's what mining engineers are looking at. You have to check every stage if it's making sense. You optimize, and by minimizing cost and maximizing your profits, by doing it with a scope that you know it's right, either technically or socially or economically or environmental aspects that you're looking at needs to be right. Then you come into the nitty-gritties, and which I'll not look at, but I just mentioned. So if you're looking at all these areas, I said, so when you're looking at exploration, so that the geology is there, so what you do is you estimate the resource itself. So you have an area that you're looking at is resource estimations, yeah? So you have excavation engineering into that. So mining has different aspects. So you specialize in one area, another guy specializes in another area. But that's why you find in a mine, you have different mine engineers with a different specialization. Like one example is a geotechnical engineer. You need to have a geotechnical engineer in every mine because of the safety of the mine itself or the people itself, people down there. Either it's an open pit or an underground, which I mentioned earlier. So how everything is done in terms of anyone who has understand like geotechnical, I don't want to go into depth into the terminologies itself. It's happened. It's applied in civil engineering and applied in mine engineering. What I always even say is mining, we construct downwards, while civil engineers, they construct upwards. Just look at that and you see it's similar, where you can go 4 kilometers down, but you have to protect yourself in terms of the stresses and all that so that you don't crumble down there. And that's what happens in the civil engineering, where you construct something up, but you need to protect it slab by slab, floor by floor. So same technique. That's where civil and mining go hand in hand with other engineering. You have design and optimization, which is my area. Underground mining has a lot of specializations. You have ventilations, you have to ventilate the underground properly. That happens not only in a serious mine, needs to happen even in the Zurura mines, the artisanal mines. So when the gemstone miners are going down there, they need to protect themselves either by ventilating the area properly. You can scale the ventilation fans and control system from a mine, which is a serious large scale, to an artisanal mine. So all these aspects, I think they're relatable to any kind of mine you're looking at, either artisanal, small scale, or large scale. I will not touch anything else because I'll just be talking to myself. These are technical things, but anything that you're looking at, like if it's engineering, the aspects that they apply there, we need to apply also in the mining industry to make it as controlled properly as other industries. If you look at aeronautical engineering, they do the same thing, optimization and design and all that. So that's what we do as well here. And you have to value whatever you're doing. So mine valuation is one area. You just can't go deep into anything without valuing the whole thing before you get into your money into whatever you're supposed to be doing. I think I'll stop there. Yes, and I think I've covered in a nutshell what mining is all about. I don't think there's anything else other than that, other than just explaining and expounding on the aspects that I've said, yes. Amanda, I don't know if I was really fast or, but I'll be welcome to any questions here.
Okay. No, you are not too fast. I think we were able to understand the process without really going into the technical terms, which is what the whole purpose of this particular forum is. So I think for me, maybe just before I go, I ask Phyllis Wangwe to come in and say a few comments. I think you mentioned just a little bit about the environmental impacts concerning mining. And I'm just curious in terms of processes and the processes involved in terms of extraction, exploration, processing, and just the whole process that you mentioned. Are there some environmental concerns that have come out regarding the process involved? Are there better processes that you can use but are more expensive? And how exactly do you go about such a situation?
Yeah. Over the years, that's one really important topic that you have to learn as a mine engineer, either in whatever level, postgraduate or undergraduate, or even in practice itself. You can Google, there are so many mines that have done it wrong, but every mine needs to do things right. I'll give examples like even big countries, like there's one case in Baimare, Romania. That's one case study that we look at every time. By Mare, there was a mine, Australian mine, which was mining gold there. There's something we call, with the tailings, the impurities that we get out of the processing, we take it somewhere. They had cyanide. And then during winter, the tailing dam burst because everything was frozen and then it started expanding and then burst. So those impurities went to a river called Baimare. And that river is shared between Romania and Hungary. That was a very diplomatical issue between the two countries, where Australia also was involved because of the mine itself. So when you're looking at a mining, you have to look really keenly about the environmental aspect because it can kill or shut a mine just by one small mistake. So when you're doing a feasibility study before you start the mine itself, because that you have to get a study, the feasibility study, which is done over some time before you get to anything serious. Environmental is one big issue where, by example, even in civil constructions, they have to do an EIA, environmental impact assessment study. So using that assessment study, you can check if you construct like Kwale, there's a dam called Kurumudzi Dam. Does it affect because it was through a river stream which was crossing through? When they use that water in the mine itself and then clean it and take it back, either by taking it back by recycling the water or just whatever you do with the water table, does it affect the people around there? So all these studies need to be done properly so that we don't kill the mining industry itself and the mine which is doing something wrong. So that's one big issue. And also in artisanal mining, it's a very big issue because like in gold mining, they use mercury and also cyanide is very dangerous, as I have said, with the Baimare situation, which is a very serious mine. So when you come to artisanal mining, they're using mercury. Mercury is very harmful to people who are doing the crude methods of getting the coal out of, the impurities out of the gold. So environment is a big issue. We are not there yet because there's some things which are not done right, especially in artisanal mining, gold mining. But I believe with the research which is going on, we'll get there. We'll get different ways of getting the gold out, because cyanide and mercury is really cheap to get the impurities out, the gold out. So yes, I understand where are there different processes which are okay than the others. Yes, they are. It's all about the economics, and people go for the shortcuts and mess the environment. But we need these resources to make our life better. So you just have to get it right. Yeah. Yeah.
Okay, thank you so much. So at this point, I'd just like to invite the participants, actually all participants, depending on how time is for us. Maybe you can just share with us, it's an open talk time, so you can share with us in terms of any technical area where mediators have not ventured, or with regards to the mining industry, and any questions you have, you can pose them to Dr. Muchiri and he can enlighten us. So I will ask Phyllis, I'll start with Phyllis. Maybe she can share with us, followed by Lily, Lawi, Patricia. Yeah, then we can go from there. Phyllis? Phyllis, are you with us? Phyllis, are you with us? Okay. I don't know. Maybe we can go to Lydia. Sorry, Lily. Lily. Lily Maina, can you be able to share with us something? Okay. I don't know. I think it seems there's something wrong with the audio. Let me try. Patricia, can you be able to hear us and share with us something?
Yes, I can hear you.
Okay.
Yeah, I think for me it is quite an eye-opener on the mining issues, and also realizing how important it is to have the various professionals that come in, because most of the time I have thought that mining is just going into the mine and a few people are involved. So I'm glad that I now know that that is happening. But I'm still at that point of wondering what sort of conflicts have come in. I heard from Rashid, he's Rashid, and I've also heard from Daktari the sort of conflicts, but I'm wondering which other type of conflicts would be there for mediators to come in, apart from the environmental and maybe the land that has been taken. But it's such an eye-opener for me. Thank you.
Okay, we'll just hold on to that question. I'm seeing Christina has raised her hand.
Yes.
Yes, please go ahead.
Yeah, I want to ask engineer a case scenario. I have land, for instance, I have land that has got some mining prospects, and it has some precious stones like coumarin, like garnet, rubies, and it's on my land. What do I do to access that? And is it, are these minerals or gemstones, do they belong to the government? Is the government to do it? Or I can benefit as an individual? And what's the procedure really for me to benefit from this? Thank you.
Okay. Thank you for that comment. I think Dr. Ri has noted it and he'll respond. Is there anyone else who would like to share? I know Patricia's comment on other conflicts, probably Rashid will come in and tackle that question. Is there any other comment? Then we can be able to tackle them all at once. Or question. Feel free to jot it down in the chat or raise your hand. The reaction tools are there at the bottom of your screen, so you can be able to share. Maybe just before we get back to Dr. and Rashid, I don't know if Lily or Lawi or Phyllis has something to say. I had called them before.
Hello.
Yes, Lawi, go ahead.
Thank you very much. This is very, very insightful. And I've learned a lot as far as mining is concerned. Mr. Muchiri, I would have wanted you to tell us more, apart from the technical aspects, what opportunities do you see for mediators in the mining industry? Thank you.
Okay. Thank you. Lily, Lydia, is there any comment you'd like to make, or anyone else in the group? I'm seeing Margaret, you have something to say. Would you just like to pose it to the group? Margaret?
Yes, my only concern with mining and explosions, what would be, are there any health hazards that the community should be aware of, and if they are there, how they can be mitigated or prevented? That's my concern.
Okay, thank you. So I think I'll just turn it over to Dr. Ari to answer the questions, and then, oh, sorry, before we go there, I'm seeing Emerald Midega has raised her hand. Let me just get her thoughts on that. Yes, hello. Go ahead.
Can you hear me?
Yes.
Okay, good afternoon, everyone. Thank you so much for this opportunity, and I can say that this discussion is quite enlightening. Having had experience in the environmental sector for a few years, and especially working under specifically working under the Water Act, what I realized was that there was a big gap when it came to stakeholder engagement, or rather stakeholder collaboration. So you find a company would go ahead, maybe do the EIA report in regards to environmental aspect. But then after they're doing the EIA report, they don't go a step further and engage the authorities regarding the specific environmental area. So for example, are you dealing with water? Then you're dealing with maybe Water Resources Authority. And then if you're dealing with the forest or the trees, you're dealing with Kenya Forest Act and the like. So you find maybe they will deal with Water Resources Authority, enter a tripartite agreement, and then they leave it at that. When they go on the ground, other issues arise, maybe not regarding water, but maybe regarding forest or wildlife, but there was no engagement. So you find a conflict may arise because they may have entered the tripartite agreement with one agency, but neglected to engage these other agencies, and confusion and conflict arises from there. And that has been my experience.
Okay, thank you for that. Antonin Jeru, go ahead.
Yes, I'd like to ask Dr. Muchiri a question concerning base titanium, the Kwale mining. I remember when they came into Kenya, they said they could not process the raw material in this country because the power requirements were far, far, far below, and so they opted to mine and just transfer it abroad. And in the whole process, a lot of value addition, jobs, and all that kind of thing, a negative impact on the economy, as opposed to if all that had been done locally. Now, in terms of mediation, I just wanted to hear from him because it's something I've followed for a long time, and I've always wanted to know. I've always wanted to know what that impact has But in terms of mediation, how we would approach that if the local community were to revisit this whole issue all over again and review the entire contract all over again. I hope I'm making sense, but it's something I simply would want to understand much more clearly. Thank you.
Okay, thank you so much for that question. I think we'll go to Lily.
Yes, thank you, Amanda. And I'm sorry, I kind of lost I lost you guys in the conversation when Daktari was speaking, but I got to hear a little bit about the mining industry. And for me, I think my take is I don't know so much about the mining industry, and I'm glad that some people have been able to highlight some of the areas. And for me, when I heard that we are discussing mining, what came to my mind was about the environment. So for me, I don't have a question, but I'll just comment and say that I think mining goes really hand in hand with environmental impact. And where mediation comes in really is in terms of public participation. Was the public involved when it comes to mining in their area? Are they well compensated in case they have to be displaced? And that is where I think mediators should actually focus on, especially in those areas like I'm hearing of Kwale, where there's mining going on. I think that is when mediators should actually be fully involved in such discussions when it comes to mining and its impact on the environment. Thank you for that conversation.
Okay, thank you so much for sharing your thoughts. I'm not seeing any other hands up, so I think let's first go and let's first give Daktari an opportunity to tackle the questions, and then we can have Rashid comment on Patricia's concerns, whether there are other conflicts that exist. So let me hand it over to Daktari to take us through.
Lawi, and I think the first person who asked a question about issues regarding to mediators, how they can come into mining industry. Once I think the first or second talk that we had, I gave an example of where I was attached with Bamburi in Mutomo, that's area of Kanziku. They were doing exploration there. And we had three companies, Bamburi, we had at the river, and East African Portland. And there was a politics behind that. But the issue was, now the politics was beyond where Kibaki and Kalonzo, then who was the vice president. But the politics in the communities, it was really visible because you could see camps forming. We had a camp for Bamburi, we had a camp for East African Portland. At the river had a small land. So the two camps, as professionals, we were okay with each other because we were just doing our job and then go back to Nairobi. But you find when you want to see the guys from East African Portland, you want to visit their camp, the guys will have a very hostile reception when we go there. And it's because they had this notion of, when it came to East African Portland and Bamburi, it's us against the others. So that's where mediation comes in. Are you benefiting as a community holistically, like the community, everyone in the environment? Is it compensation is done properly, everything? The same thing has happened in coal mining. That's why it hasn't taken shape up to now because of the politics. It comes from up, goes down, but now you find the people down there are camping inside. And that's why even Rashid said there are two camps, who are for and against base titanium. So that's where mediation comes in. Because Bamburi had a liaison officer where he needed to be on the ground to be talking to these people. Before he gets their land to drill just a small hole, they had to be compensated. You haven't even started mining, you're just exploring. That's what even Terminating did before base titanium came. They were just exploring, digging drill holes down there so they can see the rock and model the ore deposit the way it is. So because you found people there, and this thing doesn't happen only in Kenya, happen in Australia, happen in America, where you have Aboriginals in Australia and you have American Indians in America. You've seen this in the news, where American Indians, sorry, I'm in the farm, there's some noise on the background. The American Indians were they were protesting against the pipeline, which I think also in Canada they had the same issue. Aboriginals, if you Google, they always have issues where a sacred land is sacred to them, but the government or the stakeholders, other stakeholders, the government and the companies are trying to encroach into that land so that they can mine. So how do you mediate between the two? That's where you come. And other things that we need to, because the technical aspect and the stakeholders, we need to have an understanding. When you do an EIA, you have to involve stakeholders, the government, the communities, everyone living around there, anyone who's going to get involved in terms of money and all that. So any study that you're doing, you're involving people. But if you're involving people, as a company, you have your person who's a liaison officer, but the community, they need people to represent them. So people who understand this. And that's why I believe mining is not only for the mining engineers. I believe that it's for bankers because we need money. I believe it's for the mechanical engineers, we need the machinery. I believe it's for the electrical engineers. I believe it's for any scientist who's looking at plants and all these things, water, ecosystem living around the mine itself. All these parties need to come in. That's why in a mine, you have people employed in different areas and different aspects. So the mining engineer just knows what other people are doing, but technically, they are professionals in different areas. So mediators, advocates, whoever it is who's trying to mediate between the people and other stakeholders, that's where you come. And I will think of many other aspects where also in other countries have done the same thing, where mediators need to come. In terms of even the monetary value they are getting by wages, compensation. Wages meaning the people who are working, like the quality people who are working in that mine. Are they getting good pay? Are they getting, their job description, is it well structured so that they can grow with the mine itself? All these things need to rotate around the communities, around the mining areas. So secondly, we had Christina. She has a land with minerals, how to get them. The Mining Act stipulates how you can get the license. So it's easy right now. You can get to the portal and apply for exploration license, do the exploration of the mining license after the exploration. So all these licenses you can apply through the portal, the government portal. To define your mine and you get it out, you don't have the economics, you can get someone who comes and lease the land and get the mineral out. What the government wants you to pay royalties after getting the mineral out. So you need to have a license. You can't mine, that would be illegal mining. So all the licenses you have to get from the government, step by step. Explore and get and see, the government needs to see in statistics, in figures, that you have this underground there. So how do you get it? Whatever the methods and all that you have to explain. And then get the mineral license where you have to mine. Same thing which happened for base titanium. They had exploration license from Terminating. Terminating was a Canadian company. And then they sold the license to base titanium, and now they're doing the mining, which is the mining license they have now. They are trying to expand. There was some issues with that, expanding by getting other areas. So people are talking about that. So by even expanding, you have to involve other stakeholders. That's why Rashid said something about community development agreement, which is a sharing of the resources that you have there in terms of the money that they get. So that's why the Mining Act gives the power to the people down there. And if the Act doesn't give power, that's where it needs to be amended. And having even other supplementing regulations or supplementing, like the Community Development Agreement, which was done by Kwale people. It's not in the Act, but something set up by the minister, I think PS Omenge, before we got the current minister. So such things, you have to do it right. So when you have minerals in your land, if you don't have the resources, you get someone else, but that someone else who's doing the mining, follow the steps so that you're legally mining the stuff down there. The fourth question was health hazards. The same thing when we talk about environment, we talk about health hazards. So when I even teach in class, like same thing about environment, is the ecosystem. How are we living? So the amount of silica that I can inhale for such a period, the amount of uranium that I can inhale, or be in an environment where uranium mining is being done. So all these aspects, we talk about that. The threshold that for someone to die under CO, under carbon monoxide, under SO2, which is sulfur dioxide, all these things, we need to educate ourselves to so that we can understand what hazards does this mine have. Are they taking care of the environment and us? So all these studies, that's where stakeholders are involved. And if the community doesn't understand, then you need people who understand the knowledge and give it to people. So the fifth question came from Emerald Midega, where, not a question, a concern, where she was saying the lack of engagement with all government agencies. I concur with that, where we have different agencies, and we need to have either an act which governs the environment, and so that if it's mining coming into play, if it's the forestry issues, if it's the water issues, or any other issues that we have one act which can look at everything. So thank you for the comment, and yeah, I agree with that. Anthony asked about exporting raw materials. That's a very important question, because Michuki is the one who started with saying that we need to get the gold refined here, and that's why he shut some few mines. So the same thing, we had a conversation about base titanium with the minerals. And I agree with you, we need to get the minerals mined and refined and sold from here. But some things are not impossible, but impractical to do because of the labor costs, the technology, or the power, or the infrastructure that you said, like the power. I'll give an example like Australia. Australia had smelters. Smelter is where you smelt the gold to get the refined gold itself. Or iron ore, not gold, iron ore, sorry, iron ore. But right now they sell raw materials to China direct because of the labor cost, in terms of the operational cost of refining this iron ore to iron itself so that you can sell it to China. It's really expensive. So that's why you find iron ore being sold to Australia in a raw form. Are you getting benefit out of the iron ore? That's what the question is all about. Are you getting, because you find China making it really, the cost itself to refine or get the final product in China is cheaper than in your country. So it doesn't makes sense to have it refined in your country. Yes, you want to have refined stuff so that you can sell it to people, but does it make economical sense? That's the question. So if it doesn't, do it somewhere else, sell it, but selling where you benefit from the mineral itself, either in raw form or refined. But we'll always be proposing we go for the refined or mineral so that you can sell it to people. So that's a very important question, but also difficult to answer because we have different aspects that you need to look at. Straight on the last person who had a comment or a question on mediation, she said mediators can come into issues like environmental. I agree. placement of communities, and other issues that, because as a stakeholder, someone in Kwale is a stakeholder in the mine, the best titanium mine. That's why the best titanium or Bamburi, they're always looking out for the people who live around there. So are they being consulted? Why the government, because you need to operate in a legal sense. So you always consult the government, but are you consulting the communities around there? That's why you'll find mines shutting down because they didn't consult properly with the people they are living around there. So these communities and the stakeholders who are coming, it's like having a guest in your house, and the guest is trying to take over your house. So the same thing, the mining companies, they understand this, because this is way of doing things. When you come to an area, before even you do anything, exploration, the study itself is with the people. Tell them that you're coming to do this and all that. And these are the benefits, these are all that. So stakeholders meetings. This stakeholders meeting is where mediators need to come in, and other people who can help the Kwale people who don't understand where zircon, rutile, ilmenite is what about, like Anthony knows that something needed to be done to these minerals so that you can get it in raw form here. Educate these people, but tell them as well the sense of mining is, if it doesn't make sense to refine it, we can sell it to other people, get the money, because anything that you're doing has to make sense economically. So even in coal, when we talk about coal, just try and also internalize in all the aspects that we're looking at. Not just saying that coal is bad, coal is good. Get the facts and try and explain to people in the best way by arguing either for or against. And that's, I think I've covered everyone who had a question or comment. Back to you, Amanda. Yes.
Okay, thank you so much. Rashid, are you ready to tackle Patricia's question?
Yes, I'm ready.
Okay, please go ahead.
Yes, I'd say with the opportunities to practice mediation, I think it all depends largely on awareness. Awareness. The more the people are aware that there is an alternative to solving disputes, rather that is not going to court, but rather they can actually sit down somewhere, have a conversation with this mining company or the representatives of the government, and agree on how this community, this mining company is coming to do, and the benefits and possible impacts that it's going to receive. Once these things are clear to them, then it's very easy to do, for them to follow the right avenues to find justice, or rather solve their conflicts. Now, the more there is awareness about mediation, the more the communities are aware that they have their rights, and that their rights are supposed to be protected by the Kenyan laws that we have, and that where they are infringed or violated or threatened, then there are avenues that they can follow, and they are the appropriate, or there are alternative dispute resolution mechanisms which are cost effective and they save time, and they will still maintain a good reputation between them and the mining companies that are around them. Now, it is the role of the community-based organizations also to make sure that mediation, that there is an awareness on mediation. Also, the Law Society of Kenya has a duty to make sure that in the IDR committee, the Law Society of Kenya, I believe they should play a role in educating people on their rights or their opportunity to explore this avenue of conflict resolution through mediation. Now, Mr. Muchiri touched on stakeholder engagement, and it was also Emerald was also keen, and she shared about her experience in the Water Act and how she got to understand the impact of stakeholder engagement. It's clearer now that for you as a mediator, if you want to solve any dispute, wherever you are, whether it is a mining issue or a conflict in any other area, you should be able to identify the correct stakeholders. Know which stakeholders you can omit, know which ones you can keep. But in this issue of omitting and keeping in the discussion, you should also take note of the political interests of the parties, because you might omit an MCA, but he is the most beloved MCA in that community. Or you might think, I'll invite this MCA, I will not invite the MP in this dialogue, while the MP is more popular than the MCA. So you should also take note of the parties that you are involving in the discussion. I think as a mediator, once you have the right stakeholders, you're supposed to understand the actors that you are going to involve. And once you identify the actors, and this is including the vulnerable groups that are affected by the mining, and also the mining companies themselves, who are usually the main parties, then any other party to that mediation should either be in consent of the vulnerable groups or the community that has been affected, or by the mining company, whether they feel that any other person can attend the mediation. You know, as we know, mediation is a very confidential process. However, in these types of mediation, because the parties could be representatives of the large community, then the level of confidentiality is not the same as in a usual mediation of, for instance, in a family mediation. No. So once you identify the correct stakeholders and you identify the process you're going to use, then you bring in your mediation skills. Learn when to break down impasses and tensions when there's when they rise during the mediation session. Know when to invite another mediator to co-mediate with you when it is getting hot, because it is not easy to convince somebody or rather to put somebody on the same table as somebody who they view as an oppressor, or somebody who has come to take away their land, and they do not understand the benefit they're going to get. Sometimes they might need to co-mediate, because these types of mediations are very very large. They're large. It's a huge mediation. It is open, but it is still confidential. So another thing as a mediator is to remember your objective as of the mediation. Like, what are you trying to achieve? Now, your objective is not only to resolve the conflict during the negotiation, but also to create an institutional framework where now, in future, the parties know where to go whenever there is a dispute between them and the community. It is also very important to know when. Okay, it is very important to. Okay, I think it has escaped my mind, but I can say that at the end, as a mediator, you are supposed to do an agreement that provides and it includes the provisions on the grievance mechanisms and other dispute resolution processes that are likely to be able to assist in future disputes. So when you look at the diverse nature of conflicts in the area, for instance, here in Kwale, your main focus as a mediator or somebody who wants to practice mediation in Kwale will be identifying the community that is mostly affected by the activities of base titanium or the mining industries, and then strategically position yourself or position of office around there where you are easily accessible, and you'll have many different nature of cases. You'll have cases ranging from community members amongst themselves, the community members with the mining company, with the mining workers and their bosses, that is the mining company, and also in cases where, in other cases that you now be happy, and you have already advertised yourself to the community that there's a mediator. So you'll not just get these cases, but you'll also get other cases, maybe land cases that are not directly related to mining, but you might benefit indirectly through being available there as a mediator. What is most importantly is to make sure that at the beginning you work on preventing conflict. As a mediator, don't wait until the community is now in the middle of a fracas with the mining company, or it does not understand what is compulsory acquisition of their land, that you come in. No, as a mediator and a person who loves peace, you should create awareness to them, let them know what is expected of them, what the government expects of them, and what they can benefit from the whole mining industry. It is also your role to inform them about the importance of peace and the importance of welcoming this mining company, and to help them understand the way they benefit if they were to go through the mediation process in resolving their conflicts, rather than choosing the alternative of going to court, which will be very cost effective, and it takes time, and it will affect their economic well-being by using a lot of court fees to move their cases in courts. I think I've touched on very important key areas regarding the question asked, and I'd like to summarize by saying, or rather to point out on one thing that I was forgetting, the corporate social responsibility. As a mediator, you should also identify that you should also look at the opportunities that this mining company has brought to the local community. It is the duty of the mining company to have a corporate social responsibility. It is its responsibility to make sure that it provides social amenities that are necessary, especially like hospitals, schools, or water tanks in areas that are in need of water, or boreholes, or whatever that the community will find is necessary and they would want the mining company to do for them as a corporate social responsibility. It has to. So as a mediator, once you identify that these things are on the ground, you are able to understand that you are not just for the community, because it's not usually always that the community is the one aggrieved. Sometimes you are putting too much pressure on the mining company, or that pressure that the mining company is having is very unnecessary from the people, and the people are being unreasonable. So it is up to you to help the parties in dispute see what they already have and what is being done to make their lives comfortable, and to make their relationship in future much better. So I think I have answered the question, unless there is a further question which I am willing to answer. Back to you, Amanda.
Okay, thank you so much for that detailed conversation. I'd like to thank both Daktari and Rashid for engaging with us today. I actually really like what we've been able to discuss. I think there was also another forum we were talking about mining, and one of the things that Rashid has just mentioned as he closes is on the CSR, and we were even suggesting that these mining companies should take it a step further and not just provide services like the hospitals and the schools, and they were saying, and we were thinking probably, I think there was someone who mentioned that we should even look at creating income generating ventures as a form of CSR for the community. So that will be able to really solidify, and it's very rare that you find a subsequent conflict arising, because they'll be having money coming in, so they won't have any issue to probably have any conflicts, and that will settle the matter once and for all. So yes, I'd like to go back and I'd just like to appreciate Dr. Muchiri for his insights, and we hope to continue engaging with him in future and just to be able to share and learn as much as possible. Also, I'd like to appreciate Rashid for coming in and being a comment and sharing his comments during this session. I'd just like to highlight a few of the things, few of the comments I've seen in the chat as well. I think most people are learning a lot. I'm also learning quite a bit, things that I did not really know in the mining sector. I'm understanding it a little bit more, and I'm seeing Lydia has said that, no, sorry, Anne Kamunda has said that she's learning, and Wangari Kabiru has also said that she's learning a lot from this session. So we are hopefully looking forward to more sessions and to be able to learn as much as we can. And yes, so at this juncture, I'd like to appreciate everyone who's come in today, who's been able to run through the whole 3 sessions that we've had since morning. And even if you've only been able to attend this one alone, we appreciate you coming, and we appreciate you engaging with us and sharing your thoughts and asking questions and just having an active participation, having actively participated throughout this this period. So at this juncture, I'd like to turn it over to Wangari Kabiru to do the vote of thanks. Yes.
Thank you very much, Amanda. I am delighted to actually be in this session, this being our 3rd session for the day. And especially because this is the mining industry is an area for us as mediators. It's not something that we are yet conversant with, especially on the technical side. And that is why it's a great delight when we have Dr. Muchiri accepting to be with us. This is the 4th session that we are having with Dr. Muchiri. And for each of the sessions, we've been able to look at just different dynamics in this sector. And for each of the times, I assure you, ladies and gentlemen, we have discovered new things which either give us more confidence as we look into this sector. The way Wasilianahub community works is that we have a guiding strategy 2020, which came into being in December 2019. We held our strategy 2021 conference, and we identified sectors which are pillars. We have 7 key ones as the pillars, and then we have an additional 7 which are the ones that are work in progress. Our 7 pillars is: number 1, family wealth mediation; number 2, financial industry dispute resolution; number 3, commercial and agricultural industry dispute resolution; number 4 is what we are discussing on today, which is the extractive sector dispute resolution. Number 6 is a unique sector that is growing, which is around the creative economy, sports and entertainment. And then also we have, sorry, that was number 5. And then we have number 6 as labor relations. And then number 7, which is the educational sector. Number 7, which is the educational sector, stakeholders relations. You will notice that in this first half of the year until June, we will be tackling those 7 sectors, and that's what we have been focusing on, even the discussions we've been having as evening or daytime webinars during this season. And this is because we have teams that are working on developing a strategy that can allow us to be of value to those respective sectors. So if any of the sectors I have highlighted, you have interest in them, you can please bounce an email to Wasilianahub mediatorsafrica@gmail.com, indicate, and then we can connect you with the team that is a think tank. It's a brainstorming team of mediators. And the way we do it is we are not going to a sector and saying, you know, Dr. Muchiri, in mining, you people have problems, you have disputes. No. The way we work as Wasilianahub is we engage the sector first to understand the sector. Then as we understand the sector or the area, then we build our capacity, and now we can connect to the expertise and see how the sector can be able to serve much better. So just to highlight that, yeah, we have an invitation from the Association of Women in Extractives in Kenya, which is for today evening. The poster for the event, it's a Zoom call and it's happening at 6 p.m. So we actually take that this is our virtual cocktail. After we finished our session today at 6 p.m. with Honorable Wanjala, and at 2 p.m. with Mr. Lawrence Mwiruri of the NCIA, then we will join the Women in Extractives so that we can be able to, that will be our cocktail now that we can only be able to do it virtually. Once again, ladies and gentlemen, we have the next session that we will be getting into, which is the session with Mr. Lawrence Mwiruri of the Nairobi Center for International Arbitration. We look forward to be able to have that time with you. And most of all, the reason why we are really, really looking forward to that time is because this is the opportunity that we have for us to now understand what does NCIA do, that's the Nairobi Center for International Arbitration. How do we as mediators engage with the Nairobi Center for International Arbitration? The Nairobi Center for International Arbitration is the one that kicked off to us in the public face the ADR policy. The ADR policy is ongoing. The Attorney General set up a team. So what is happening? What is perhaps happening? And also, how can mediators proactively engage? What is possibly the direction that the mediation practice would go in Kenya? And how else can mediators shape and reshape themselves? So ladies and gentlemen, we are looking forward to see you at exactly 1:55 p.m. And that session will run on until 3:30, and it includes first Mr. Mwiruri taking us through the United Nations Singapore Convention on Mediation, which touches on commercial mediation, and then the discussion will now move to the Nairobi Center for International Arbitration. The session that will follow after that is at 4 p.m. And please remember that the login that you have today is a free access for all these sessions that we are having at our Kenya's first virtual mediation symposium day in 2020. And so take your lunch or take your water, take your breather, and yeah, please remember to join us. The last session we will be having in the symposium day is on the family wealth mediation with Honorable Moses Wanjala, who is particularly for mediators, they know him more the Mediation Accreditation Committee. He's a magistrate and a registrar in the Office of the Chief Justice, the Judiciary of Kenya. So what is working well and what is not working very well or could get better in the area of family wealth mediation? This is tackling on aspects of inheritance and succession, which are a lot of cases that are in our courts and even in our homes. Many of them relate to this. And you notice that it was pillar number 1 for Wasilianahub, because for us, we are saying that we need to have families' wealth work, because it must be multi-generational wealth, and it is possible. So again, I say thank you very much, Dr. Muchiri. It's a great delight all the time to be with you, and also all the other colleagues. Amanda, thank you very much, and Amanda Maseno for your moderation, and Mediator Rashid Bwiza, it's always a delight to have you engaging with us, and I really, really thank you for being proactive and also stepping up. I recognize young mediator Lily Maina, who is a part of the rapporteur team and also supporting us on the social media side. So thank you very much. And also she's a speaker at a couple of our sessions. In the event you have not been, or you do not receive communication from Wasilianahub, we have posted on the chat the email address. Please send an email and you'll be able to receive continued information, and also in case you need support to be able to join the Kenya Mediators WhatsApp group, where we can all be sharing what's happening and also new things and activities that are going on with other people, just as a generous community. Yeah, you can get in touch with Amanda and she will be able to support you in that. So I'm looking forward to be able to see all of us at exactly 1:55 today. And really, I thank you, ladies and gentlemen, because spending time with you is enabling us to be able to have a great, great celebration of what is the 3rd anniversary for Wasilianahub since we kicked off the work as a tech justice innovation, and we are looking forward to engage with you more and more. In the event you're also not listed on the panel for mediators, please visit wasilianahubmediators.co.ke, where we have the current free listing for mediators, as we are soon opening up the premium service for it. Thank you very much, and God bless you. Amanda, over to you. God bless you.
Thank you for that vote of thanks. So at this juncture, I'd like to close the session, and we'll close the session with the national anthem. And yes, O God of all creation, bless this our land and nation. Justice be our shield and defender.
May we
Dwell in unity, peace and liberty. Be found within our borders. Okay, thank you so much. We'll see you all at 2 p.m. on the dot, and we'll be able to continue with the sessions for today. Thank you.